Hello everyone and welcome to SEO's breakdown of day 13 of arguments in the Article 370 case. In the previous hearings, the bench had asked the Solicitor General of India to submit information on a blueprint or a roadmap chalked out for the reorganization of Jammu and Kashmir and informed them when elections would be conducted in the state. The Chief Justice had also asked Mehta when the union planned to reinstate Jammu and Kashmir's statehood. On day 13 of hearings, Mehta came to court equipped with different data points but didn't commit to a date by which Jammu and Kashmir would be made a complete state. First, he submitted that the union is ready to announce elections in Jammu and Kashmir any time now. They were simply waiting for the Election Commission to complete updating the voters list in the state, which is substantially over. He then reiterated that for the first time, a three-tier Panchayat Raj system would be introduced in Jammu and Kashmir. So, Panchayat elections will be held first, seeing as district elections had already been conducted. In Ladakh, the Leh Hill Development elections had already taken place, and the Kargil Hill Development Council election was scheduled at the end of September this year. Municipality elections will follow, and then Legislative Assembly elections will be conducted after that. The scheduling is based on data that suggests improvement in the law and order and development situation in Jammu and Kashmir, Mehta said. Since August 2019, among other similar metrics, terrorist-initiated instances had reduced by 45.2%, infiltration, which he said was a major issue in the region, had reduced by 90.2%, and law and order events had reduced by 97.2%. Mehta emphasized that this was not only because of increased security personnel, but because of gainful employment of the youth, who were misled by secessionist forces and forces outside the country. Organized bunds by secessionist forces, which were 52 in 2018, had also dropped to 0. Attorney General R. Venkatramani's focus was on the President's power to repeal Article 370. He stated that the President was not limited or paralyzed by the situation of impossibility, which in this case is the lack of a Constituent Assembly. You'll remember from our previous videos that Article 373 requires that a Constituent Assembly recommend the abrogation of the provision. Venkatramani argued that it was impossible to get the recommendation of the Jammu and Kashmir's Constituent Assembly because it did not exist after 1957. So, the President is empowered to take stock of the situation in Jammu and Kashmir from time to time and decide when the abrogation of Article 370 is necessary for the state. Senior Advocate Harish Salve argued next and said that constitution framers were apprehensive of the troubled history of Jammu and Kashmir. Considering the sensitivities of the border state, they were compelled to agree to a system where Article 373 would act as a safety valve mechanism. This fail-safe would ensure that if the political compromise in 371 failed and there was a need to pull the plug on the agreement between Jammu and Kashmir and India, Article 373 would be that plug. Senior Advocate Rakesh Dwivedi was the last counsel to argue for the day. He contended that the President's power under Article 370 was neither an executive one, like Senior Advocate Kapil Sibal had previously suggested, nor a legislative one, as Senior Advocate Harish Salve argued. Rather, it was a constituent one that was built into the original Constitution of India. Justice Khanna disagreed and pointed out that the only constituent power was the power to frame the Constitution itself. Everything else was either a legislative power or an executive one. Dwivedi maintained that the President's power under Article 370 were much wider than ordinary executive powers. Dwivedi will continue arguing on September 1st, 2023. Thank you for watching SEO Daily. Stay tuned for more updates from the 370 hearings and visit our website seobserver.in for detailed reports, analysis, and more.